Welcome. So today we are doing agency fundamentals. This is going to basically the idea here is whether you're new to KW, new to the industry, or you just need a refresh because it's overwhelming and confusing from time to time, is to make sure that we are communicating what our expectations are and how we function from agency, because we really want to make sure that when you're going out and doing your business that you are strong in your convictions on how you need to work and what the ground rules are. And this is ultimately 100% of this course is designed to protect you as an agent so that you can have long, successful, and profitable careers in real estate. So what I am going to do is I'm just going to share my screen for a second, and we're going to come kind of in and out of this as we go so that we're looking at people most of the time versus just my super exciting timetable. So the goal is that we will be able to get through this course in approximately 45 minutes. That's my goal if I talk succinctly. And then we would have about 15 minutes left for questions. So I am going to ask if you have, we're going to do this in sections. Okay, so we're going to do the BDBA, the SDBA, we're going to do the customer status, and we're going to do transaction brokerage. And oh my goodness, my OCD about formatting, I didn't bold that, but you'll forgive me. And so the idea would be at the end of each section, if there's something major that I haven't covered, we'll try and address it then if we can, and then we can move on successfully to the next piece. Does that work for everybody?
Yep.
Yep. Okay, perfect. Okay, so we have, before we get going, I just want to make sure that everybody knows we have a really amazing group of people on the call today. We have some agents with a lot of experience. We have agents where the proverbial ink is barely dry on their license. And we have other people who are kind of, 6 months to a year in. So this is a really good mix of people to have a really cool discussion as we go through. And this is going to be absolutely open for conversation as we go so that we can learn from each other and share. So I'm going to get started right away if that's okay, because I really want to respect your time and your commitment. So first of all, can everybody see my screen?
Yes.
Okay, perfect. Okay, so I'm going to also open up the chat thing. So if you have a question, you can, depending on what it is, you can throw it in the chat and then I can sort of get to it when I think is the right time necessarily as well. If I miss something that somebody posts in there, please let me know and I'll make sure that I direct my attention back to that. So I'm going to start with what is ironically the most complicated in some cases of all of our documents, and that's the buyer designated. And this is the one that's the hardest for everybody to kind of get their heads around. And it's the one that makes everybody the most uncomfortable. So that's why I wanted to start with it first and get it out of the way so that we can move on to some of the easier ones. Does that work for everybody? Yes,
yes.
Nodding yes. Perfect. Yes. Okay, so first thing is, what is the purpose of this document? So when you took your licensing course or when you might have been with a different brokerage, there's all different theories that sort of are moving around in I'm going to call it the rumor mill of our industry on what is the purpose of this agreement. And I want to make sure that I am extremely clear on, hi, Shelley.
Hi.
on what the actual purpose of the buyer designated agreement is. I'm going to break the myth. It is not about you getting paid. I know that's what you'd like to think it is, but that is not the purpose of this document. The purpose of the buyer designated agency agreement is to establish to a consumer what your job is to protect them and how you are going to advocate on their behalf and how you're going to be their agent. And what being an agent means is it's a term under law where you are representing them, speaking to people on their behalf, negotiating on their behalf, and basically they are giving you the legal authority to advocate and protect them and work for them. That's what the agency document is about. And if you think about the actual buyer designated agency agreement, the first section talks about what is the brokerage going to do. It's going to protect and promote the interests of the consumer at all times. We're going to keep confidential their information from another consumer's information, follow the laws of the province of Nova Scotia, blah, blah, blah. That's what's on the left-hand side of the document. Then on the right-hand side of the first page, it talks about all of the things that you are going to do to assist your client. You're going to search out properties, including those that are not listed on MLS. You're going to negotiate favorable terms, prepare and present documents, recommend when they need to speak to professionals, etc. All of those things on that first page and into the second page are covering your responsibilities. And the easiest way to explain the buyer designated agency agreement is that it is a document that binds you under law to do your job. And that's why it's about attitude, about how we look at this document with respect to how we work with it with buyers. If we have the mindset that we do the working with a realtor where we say, this is in theory how it's going to happen, that I'm going to do all these things when I have you under agency. And now this is the contract that promises that myself and my brokerage are going to uphold those responsibilities. And if we don't, we are in very serious trouble. And we take these responsibilities so seriously that we are signing on the dotted line and committing to do these things for you. That's what the buyer designated is about. It also discloses how you're going to get paid and what the term of the contract is. It's also a loyalty document. It is also designed to ensure that that client is not under contract with someone else, so they're not getting conflicting advice, and that if you do your job upfront with no cost to them, that when they do purchase a property, guess what? Yay, you're going to get paid, and how you're going to get paid. So that is the overall purpose of the document. The purpose of the document is a commitment and a disclosure of your responsibilities to the consumer. It is not meant to tie you to the consumer like lead shoes in the mafia, where this is how you're tied to the client. That's not the point. It's enabling you to work outside of common law and to represent that client. Before we go into compensation and timing, does anybody have any questions or comments on the general purpose of the document? Is this what you thought it was? What are your thoughts on this?
It's what I thought it was. I don't see it as just a way to get paid. So that's not my attitude.
Well, then yay, because that sets you apart from, unfortunately, there's an awful lot of people who view this as a contract for services for payment. And that is an aside of this document.
Well, that's a part of it.
It's a part of it, but it's a disclosure part of it, right?
Yeah.
The other piece of it, I can tell you from the Real Estate Commission's perspective, they honestly couldn't care less if we ever got paid for anything. That's not their point. That's not the point of the document. It's to make sure that the consumer knows, what are we supposed to do? Who are we allowed to talk to? What are fiduciary duties? And that I've committed to them. And oh, by the way, when I do my job, this is how much I expect to get paid. And I do expect to get paid. I know this is not a charity, right? But it's not meant to be a contract designed to just go and start suing clients for payment. That's not the purpose of the document. Does that make sense for everybody? Anybody else have anything else they want to add other than what Michelle had said? Nope. Okay. So the compensation clause. So this is the one that freaks everybody out about the buyer agency document, is the compensation clause. And this again goes back to the spirit of the document. It is designed to disclose to a consumer how much you are going to get paid. And I'm going to give you an example. Some of you have heard me do this before, but I'm going to do it again. So let's say, so when you first draft the document, you have to put a number in, 2.5%, 3%, 20%, I don't know, put whatever number in you want. But what happens is then when you actually find the property that they want, if the number doesn't match what you have in your agreement, then we need to make some decisions. Either the consumer maybe makes up the difference, or if it is less, because usually it's less, not more, that you would get, pardon me, you would then have to amend the agreement to reflect the number that you're actually going to get. So if you put 2.5% in, then what would happen is if you happen to offer, let's say on a military relocation property, which will be at 2.2%, it's not negotiable, that's what the government pays, you would likely then amend your buyer designated agreement to state that For the purposes of purchasing 123 Smith Street, the compensation in clause 6.1 will be 2.2%. So then I haven't changed my agreement permanently. If this deal doesn't come together, we go back to my regular 2.5. But if this deal does come together, then that's what I will get paid. There's a reason why this has to happen. If you had if you had a client who was torn between two properties, and one was at 2% and one was a super motivated seller and they had it at 3% to try and attract more buyers. And your client is there, oh my God, which one? You're giving them statistics and information and breaking things down and doing what you do to help advocate for your buyers. And you had said, both have good resale value, et cetera, and they happen to pick the one with a 3% commission payable to you. But your buyer designated says 2.5, and you forget to mention that this one is going to happen to pay me more. If later in the future there was a problem with that property, because let's be honest, it's going to be a problem when you got paid more, not less, and the consumer, files a complaint, or if there's ever a court action, and you earned more money than you disclosed to that consumer, it could be viewed that you pushed that client towards that property because you were going to make more money. So that is the purpose of the compensation clause, is that we do not have the right to be paid anything different than what we have disclosed to our clients. Think about your seller agreement, which we're going to talk about in a minute. We don't get to charge something other than what's in the agreement. Fair? If we could just, I took the listing at 5%, but you know what, on closing, you were really difficult. I think I'm going to charge you 6%. It doesn't work like that. We only get to charge what was in the agreement. Fair? The buyer agreement is exactly the same. Our commission statement and your commission check has to match the document as to what we have disclosed to our consumer that we are going to get paid. And if you have to get paid less based on whatever arrangements or negotiations or the particular listing, and you then amend it to go down, then your client is also seeing that you are fully transparent and you are working for them, and essentially in some cases taking a pay cut to make sure that they get the right property. It could be exactly the same, but your commission has to match, because it's about transparency, because it's about ensuring that the consumer always knows that your motives fall within your fiduciary duties, a full disclosure, and that is a piece of it. So that is what the compensation is. Now, there are going to be exceptional circumstances where you might have a client who you've worked with for X period of time and they go off and they buy a house at an open house and you've worked really hard. And those are circumstances where if we have a properly filled out buyer designated, then I can go to that other brokerage and go, excuse me, hello. We need to negotiate something here because we have a client under contract. But that is not the purpose of the document. If it's properly completed and somebody breaches the agreement, meaning a buyer potentially, hopefully not you, then it does give us some potential if we are going to go look for compensation or a financial remedy for you. But I need to make sure that that is not the way we are looking at this document. We're not moving forward with our contracts with our clients with the spirit of litigation. I don't think that's how any of you are working. Okay. Does anybody have any questions on that compensation section that I haven't covered?
I have a question, Anne.
Yes.
So, most of the time, we normally, see nowadays 2% commission on properties, for our buyers. So is that commission negotiable from the seller side? Like, do you normally negotiate that? Can we negotiate that?
You can. So there is a way that you can add a clause to an agreement of purchase and sale. And I can certainly share that wording with you. Essentially, it says in clause 7, you would put 7A, that the cooperating commission is to be 2.5% plus HST as per the signed buyer designated agency agreement with the buyer. You need to have a conversation with your client wherein you advise them. So my advice to you is that I would never recommend that you allow a client to lose a property over 0.5%. And it is a potential where you would say to your clients, like, this is what I'm putting in, this is what I'd like to get paid. If this becomes a hill we're going to die on, then you know what, we'll remove it. It could get countered out. If you're in a competition situation, I would definitely not be putting that in. if it was listed at 2% and you were competing, because I don't think you'll win. That's a strategy perspective. But that's where you need to have a discussion with your client as to whether you are prepared to amend your commission your buyer designated to change it to 2%, or are you expecting your client to make up the difference? That is between you and your buyer as to how you're going to do that. And if you run into those situations, then you should consult with a broker as to what is the situation and how you should deal with it. Does that help?
Okay. Yeah, thank you.
You're welcome. Okay. Any other questions? Okay.
So,
So-
sorry.
Okay.
So, because I don't have
Iris?
the, yeah. Sorry, and because I don't have the agreements with me right now. So I just by memory, maybe I'm wrong. So each buyer designated agency agreement, there is a property address, right?
Yes.
So each agreement is for each
No.
prospect.
No. Our
Okay.
recommendation on how to do, okay, so let me clarify. Yes and no. You can do a buyer designated agency agreement with a client, one property at a time. That is only for that one property.
Mhm.
You could have a consumer who says, look, I have relationships with 3 other realtors, but I'd like to use you for this one. If it doesn't work, I'm not prepared to be committed to you to every property that I want to buy, but this is for this property. But
Yeah.
generally speaking, we would recommend that you write 2 words under the property address, that you
Mhm.
write Nova Scotia,
Okay.
not HRM, not Hants County, not Shelburne, not whatever, Nova Scotia. And that
All
way,
right.
if you have a client, so let's say if you are, so I'll use Halifax just as an example. If you wrote HRM, which we used to see a lot of people do, and the client buys a house in Elmsdale because they walked into an open house with another agent,
Mhm.
Hants County, there's nothing I can do to get you paid.
Okay.
Okay, the boundary line is what you wrote. So typically our recommendation is if the client is agreeable and they're creating basically a full relationship with you where they want you to search for any property in any area, etc., you would write Nova Scotia. If you have a consumer who goes, well, I think I want to try you out first, or I have other relationships, then you would write just the property address.
All right. So if we write like Nova Scotia, but and we write the commission percentage is say 2.5,
Yes.
and finally we get the like a deal based on the commission percentage is like 2. So
Yeah.
should I like do the amendment?
You do an amendment to the seller or to the buyer designated, and it's really simple. It just says clause 6.1 commission commission remuneration for this particular property. List the property is to be X, 2%, 1.8%, 3%, whatever it is. Okay.
All right.
But always put the property address in your amendment, because then if that
Yeah.
deal falls, you don't have to re-amend your buyer designated.
Okay.
Oh, I didn't know that.
Right? Because if not, you're continuing to fluctuate your whole agreement, but really it's about this one property,
Right.
right? And you would sign that amendment at the same time as you wrote the offer on that property. That's when that amendment should be written, because then the client is aware of the disclosure as they go to the deal. If you write it after, then they've already agreed and done conditions, then they're tied to the property without knowing your financial motives. So your amendment to the buyer designated, if you're reducing your commission, or especially when you're increasing your commission, it should be done at the same time you write that offer. So as you draft the offer, you send them a separate document in your DocuSign at the same time that says, for the purposes of writing the offer on 123 Smith Street, the compensation of BDA is to be X. Okay, does that make sense for everybody?
Yep.
Okay.
So
Great.
Anne, I have a question. It's Marianne.
Yes, Marianne.
So if someone has signed a BDBA with another agent, and on their BDBA they signed a particular address they were looking at with that agent, they're open to you to sign a BDBA on something else.
Everything else, you
But
just can't sell them
But
that.
at that point, you couldn't put Nova Scotia or Cape
No.
Breton because you have to eliminate
You could, if under additional provisions, you exclude the other address.
So how do we know? Because most buyers don't remember what they signed.
Yes.
How do we know what the other BDBA signed? And can we ask the
They should
other agent?
I wouldn't do that.
No.
Your,
How do
your
we find
client
out?
should have a copy. Remember, one of the requirements of all of our agency contracts is that the consumer receives a true copy.
Mhm.
So your client should have a copy. If they don't have a copy, then they should be reaching out to that brokerage and requesting a copy.
And once they have a copy, we would
Then-
then know the duration of that.
You'll know the
Contract as
duration,
well.
you'll know the details. Please remember that you cannot, number one, you cannot induce a client to terminate an agreement with someone else, just like they can't do that to you. You get what you get,
Yes.
right? That's a rule. Secondly, that somebody saying, yeah, that's okay, I'll let you out, is not the end of an agreement. There is a formal termination agreement. So if you have a client who says, no, so-and-so says they're going to let me out of my agreement, then you need to say, okay, when you have a copy of your termination agreement, you can let me know and send me a copy, and then we'll go from there.
Okay, so if you wanted to terminate a client, you do a termination of the
There's a
agreement. of purchase
termination
and
of an
sale.
agency relationship document, right? Just like
Yes, okay.
terminating, it's the same as terminating an SDBA. You just tick at the top, buyer agreement, seller agreement. They made all the forms sort of
Okay.
neutral, okay? But
Fortunately, I've never had to use one, but yes. Okay, I'm
Yay,
sure it's
that's
there.
great. Yeah. So, but that's the concept. Like it's an agreement. You can't end any agreement, listing agreement, agreement of purchase and sale without a form. Of course, there's a form, right? So this is the same thing. Okay. So in terms of when do I need to get it signed, this is the big question that people say, because in designated, we're supposed to have them signed toot sweet, quite quickly. Okay. But right away does not mean I will not show you a property if you don't sign, in blood before we get in the car. Okay. What is the threshold for when you need to have it signed is when you start to give advice. Okay. Advice is the trigger. It might be that you've interviewed
Okay,
each
I'll
other,
have to ask and I'll get back to you.
but it might be that you've interviewed each other and you're going out to look at one or two properties and you've decided, yeah, we're the right fit. We're going to continue to do this search together. And we're going to, basically agree to be partners in the search for your home. And I'm going to advise you, I'm going to set you up with a mortgage person. I'm going to get you pre-approved. We're going to do a wants and needs session. We're going to be discussing your bottom line and what you want in a home. That's advice. Now we're into signing a buyer designated. And when you're conveying the buyer designated to a consumer as what it is, it's a promise of my doing my job. And if I don't do my job, then I could be disciplined. And this is not about my getting paid. It's going to show that I'm going to do my job for you. And oh, by the way, good news, you don't even have to pay me. People are not resistant to signing it because you're promising to advocate for them and promising to work on their behalf exclusively. It also shows them that you don't have any conflict with the seller, that it doesn't matter if the listing was a Keller Williams listing, because this creates a cone of legal protection around them. And essentially, if I have someone under agency and I want to write an offer on Michelle's listing, it's no different than if she was with Remax Royal LePage or ABC Real Estate, because I'm going to fight to the death against her, just as if she was somewhere else, because that's my agency relationship. We never have to step outside of advocating for our clients. So when you explain a buyer designated from that perspective, people are not stressed about it. If you ever feel you need to write in a clause that gives your client some kind of an out, that given such and such a notice, we have a 30-day honeymoon period or something like that, you can reach out to me and I can help you to create something like that. But I'll be very honest, when you explain the buyer designated the way that I'm talking to you about it, which is the purpose of this agreement, people are not concerned. Okay. What are my duties under the agreement? This is just a very quick overview because I think you guys are pretty clear on what your job is with respect to that. But the main thing to remember is the loyalty and confidentiality, and that your duty always lies back to the person to whom is on that agreement. That, it's They are your principal and the person that you look after, and you need to do everything you need to do to protect and promote their interests at all times. And that's really the main thing. It's listed on page 1. If you ever have questions about, is this my responsibility or should I do this, just reach out to one of the broker team, and we'll be happy to go over that with you. Does anybody have any other questions on the buyer designated before I move on?
I've got one, and it's David James.
Hi, David.
Going back to the discussion about the commission rate being different, is that a conversation you would have with your buyer as you're doing the BDBA, or only when that situation comes up?
My personal recommendation is I would let them know that it's a possibility, and that is because it's about transparency. So when you're starting your relationship by saying, my job is to make sure you know my motives are pure all the way through, and that this compensation clause is about disclosure. So if the property we pick is X or Y, then this is how we're going to deal with it, because you need to know all the way through the transaction how I'm getting paid and things are moving. When you sort of spring it on them in the middle, especially if it's a bonus commission that went up, it's a really difficult conversation at that point to have, David. I'm sorry to say it's not the common conversation you're going to have. It's usually that it's going the other way, but there are some sellers who offer, bonuses. We're in a bit of a seller's market right now, so it's a little bit less, but we were in a buyer's market for a couple of years where sellers listings they were on the market for 180, 365 days. So they were switching it and offering 3.5 to the street, selling bonuses of $2,000 and $5,000 if you got a closing date by X time. So if you suddenly have to then say, oh, by the way, the house you picked, they're going to pay me another $5,000, and you haven't talked about that up front, it's going to have a weird vibe. That's just my opinion, right?
That's good advice. Thanks.
Okay. We have a question in the chat from Kelly. If I use Nova Scotia as the address, do I have to do a second BDBA once I have an actual address when I'm writing an offer? It's an excellent question. No, you do not. You're good, because unless you are trying to write something outside of Nova Scotia, which you're not licensed to do here, and you wouldn't be using Nova Scotia forms, you're good. You're within the purview. Yes, the goal of this is less paperwork. I know that sounds weird coming from me, because y'all think I just love paper. I mean, I do love paper, but that is not the point of this. The point is that you have one BDBA, and then you're good to go, right? You can, if you write a deal on this property and, I don't know, the septic failed and you walk away and you go to the next property, I don't need to do anything on my BDBA as long as the commission hasn't changed. Is that clear for everybody?
Yep.
Okay.
I have one question.
Yes, Shelley.
You said true copy.
Yes.
Is a true copy a piece of paper that you hand to them directly, or is the dot loop or DocuSign a true copy, considered a true copy?
That is another excellent question. Yes, a digital copy is a true copy.
Yes.
But you have to make sure, if you're doing it in DocuSign or dot loop or any other digital signature program, that your client has actually created an account. Because if not, they don't have access to it. They've signed it, but then they don't have it. Does that make sense? So they can't log in and see it. They signed it, but they don't have it anymore. So you want to make sure that they sign up for their free account. Otherwise, you can create the habit of, as things are signed, you can either create a shared Google Drive folder or cloud folder, or maybe you email them a copy, so that it's just a practice to make sure they always have a folder. They always have it. If they don't want to commit to the free account because of whatever, there's definitely people who don't want to sign up. So you need to ask that question, because they need to be able to refer back to these documents.
Okay. And does dot loop or DocuSign, I know we're using DocuSign, some of us are, does it prompt you when you?
It does, but they may not realize the importance of it. So if you are setting your clients up for electronic signatures and you're preparing them to, click to accept the pretty signature, don't try and draw with your mouse because it looks like you're signing for the UPS guy while you're with the little stick in the cold, right? That to accept the beautiful signature, we know it doesn't look anything like yours. It is a legal signature because you signed in through your secure email, etc. When you give them that spiel, The next piece is you're going to want to download the app onto whatever devices you have. So when you're in Costco, 6 feet apart from the other person signing your document that we've just talked about on the phone, you can do it right on your app. You don't have to be with your spouse or whoever. And by the way, please set up your free account because it is unlimited digital storage of all of the documents we will have done together. If they do not do that, then you need to have that conversation. Do you want me to email you copies of things as we go? Would you rather I set up a shared Google Drive folder and then, you know, you keep a folder with, you may have a folder, let's say with all of your documents, and maybe you're not giving them every single thing at the same time, but you have a folder, client copies, you share that folder with them. And as you do things, you drop your documents into there. If you have a client who is not signing electronically, and we do still have clients who where, you know, that is not their reality, then you need to mail a copy. You can bring 2 sets and have them sign 1 copy and stamp the other side copy and have them sign that set, depending on potentially on the age or the technological sophistication of your client. But they do need to receive a copy, but electronic copies are considered copies.
Okay, that's
Okay.
great. Thank you.
You're welcome. That's a great question. Thank you for asking that. That kind of goes generally under agency, so it fits, you know, and above all, overlying, make sure your clients have copies of all of their documents. And it says in all of the documents that they will have received a copy. And you've had it happen where, you know, Mary Ann was saying the person doesn't know what they've signed. So where's their copy, right? That is a huge issue. If you have clients who have not received true copies, that agreement can be null and determined null and void by a broker, by the commission, because you're instantly in violation of the terms of the agreement.
Okay.
Okay. So moving on, the seller designated agreement. So this is going to mirror very similarly, and it seems almost silly in a way that I have it written here because it's exactly the same as the buyer agreement. And that's the mindset that we need to have. We don't list clients' homes without listing agreements and an agreement and a transparency on what my job is, what I'm going to do, and how I'm going to get paid. And a buyer agreement is exactly the same. But when we're dealing with the listing agreement, obviously the purpose is to give you the exclusive right to market and sell this property and to put it either on the MLS or not, depending on what you're doing. Something that you should know is if you're interested in doing coming soon properties, does anybody know what I'm talking about there?
No idea.
Okay, so we have a couple, I saw one hand, but I can only see so many pictures at one time. So what coming soon is where you're trying to create some marketing enthusiasm for your listing.
Oh, I do know.
That's okay. It's all right, Shelley. But what's very important is you cannot put up a coming soon rider if you do not have an exclusive listing agreement signed. And please note that coming soon is exactly what it means, coming soon, not coming in 3 months where I've got the sign sitting up there for all of this time and nobody can go in. It's really meant to be soon, right? Now, soon is relative, but I would say a week would be sort of the maximum amount of time that would be expected for coming soon, but you must have an exclusive agreement. And if you do not, then you are in violation of your duties by advertising a property that you do not have the right to do. So when we're talking about when do I need to get my seller designated signed, this goes back to exactly the same philosophy as when I am dealing with a buyer. There is, I'm going to call it a very bad habit that every real estate agent has, which is that I could be working with a seller for 3 weeks before we go live. And we're helping them get the property prepped and we're advising them on getting the plumber. We got a painter in and we're crunching numbers with the mortgage broker to make sure everything works so that we're ready to go to list the property so that we're set to go live. So what am I doing while I'm doing that with my seller? Can anybody tell me?
Advising.
Right. Bing, 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 I'm giving advice. So when do I need to be under contract with a consumer?
Pretty quick.
When I
Before
start to give
advice.
advice, okay? This is not necessarily about preventing your seller from selling the house from under you, although I will say it certainly does help that they haven't gotten so far through with you and then the neighbor knocks on the door, but you don't have a contract and so they can actually sell it privately and you're kind of SOL. It will protect you from that. But from a legal perspective, if something happens and you've been giving all of this advice to your sellers and you don't have them under contract, it's no different than wandering around with the buyer and signing your buyer designated on the day you write the offer. It's exactly the same thing, which we're not supposed to do, by the way. So when we do our seller designated, one thing you can do is that you can put a client under exclusive agreement, and then you just simply need to do an amendment to the SDBA when you're going to go live. So you write your listing agreement, you do everything else, and then you basically, when everything's ready, photos are back, pardon me, measurements, you know, staged, ready to go, we're going to pull the trigger, you can do your amendment and say that the listing agreement is now going to be active on the MLS system effective X date. Or if you already know what your start date's going to be, you can put that right in the listing agreement under additional provisions that effective blah, blah, blah date that the property will be active on MLS by no later than X date. Using words like no later than allows you to activate it earlier without having to do an extra amendment to tidy up the date. When it goes live on MLS, the date that you said it will go live by or earlier than is the effective date on MLS. It will not look like an old listing. So I can take that anxiety away from you. You could have someone under exclusive for a month while they're getting ready and you're advising them and working with them and you've sent the photographer in and you've done all this, and then you have that it will be going live by no later than whatever date. Does that help?
Yep.
So it allows you to do coming soon. It allows you to advise them all the way through. It allows you to be protected so that they cannot sell it to a neighbor or someone else in the interim while you're doing all of this hard work and spending money, okay? And that's why I have the exclusive MLS or combination option. If you're not sure based on your particular scenario, you can reach out to myself or one of the broker team, and based on what you're doing and the timing, we can let you know what we would recommend. Does anybody have any other questions about seller designated? Oh, one thing I did miss is my own note there. The compensation clause and what we expect at KW. So let's chat just quickly about that. So as you have all mentioned, there's a lot of people who are offering lower commissions to cooperating agents. Is that a fair statement? Yeah.
I don't know, is it? Or are they just taking lower commissions up front and then just splitting it? Nobody knows.
We don't know.
For the
We
person.
don't know the answer, right? Because we don't see the other side. We only see our side. But one of the things, so there's a couple of different pieces. So one, if you are challenged in, getting your unfair share, for lack of a sales, a salesy sentence, and being comfortable in asking for what we would consider, remember the Competition Bureau, this is not a standard in the industry, but what we would like to see for our individual agents at Keller Williams, we'd like to see everybody listing at 5% and more, because we want you to have viable businesses that will cover your expenses and allow you to live the life you want and get paid for what you do. There are always circumstances where that is not possible. The general policy is that at Keller Williams, if you're going to list for less than 4%, you need broker approval. And we are looking to see that on listings, we are looking to have, our goal is to have 2.5% of the street, so that if we are discounting on our end as a listing agent. And the question is why? Why do we have that philosophy? And it goes back to the concept of my fiduciary duties to my seller and attracting as many agents and the best clients and the best quality offers to them by offering a highly competitive commission to draw back in that clients, and have an agent who may be motivated entirely by commission pick your property over a similar property that is paying less. And I'd love to tell you that that's not the case and there aren't agents who make that decision, but this is an independent business and people are going to make decisions that are their own. And so that's what we're looking for. And we would rather teach you how to sell your value proposition and how to help you handle those objections with sellers to try and get the best possible commission rate for you. It's not always going to be possible. There's always going to be some extenuating circumstances, but that's the goal, is to stabilize your income by being able to know you're always going to get a certain percentage. And that's really the goal that we have, because I can tell you that 0.5% or more over a series of deals over the course of the year, this is a significant amount of income. And your expenses, tracking them and making sure that you're making that right lifestyle based on what you're doing. That's the part of it, right? We can't always get it, but that's our goal. Okay. Does anybody have questions about that? Okay, so moving on, customer status.
Actually, I'm sorry, I'm interrupting, but are we like, because I know that a lot of people want options for services, are we allowed to say 6%, but 4% is staying with KW side?
You were at 6%, we would be looking for 2.5 to the street, absolutely.
Well, that's what I meant. I just did math wrong. But yeah, 2.5 for them, and then the remaining, are we allowed to do that?
Yeah, you do not have to share fairly, but we are looking for 2.5 to the street.
Okay, that's great.
Okay.
Thanks.
That's our goal, right? There are always someone's going bankrupt, there's a death, there's no money in the house to pay it out if it's like, there's always the odd circumstance, but the goal is to teach you and train you and help you be really confident and offering strong value, that commission just doesn't become a question, right? Because you are offering such great value that they don't question what you're charging, right? We'd rather focus on teaching you that than the other, but we are looking, our goal is 2.5 to the street, because we want to be leaders in having our industry help our sellers, because there's no question, you know, that commission rate can attract great deals and great terms for your seller, and that's our job. Make sense? Okay, so customer status and fee agreement. So this is a really interesting one, because it seems like a weird thing to have under agency because it's the actual no agency document, but it is relevant to agency. So who can be put under customer status and fee agreement?
Those who you're not advising.
Right. So is it just like FSBOs? What are we doing? Who can we put under this?
So some builders don't pay, like, work with Provident,
Yep.
and we have to do like a fee agreement with them,
Yep.
because they don't list the properties directly on MLS. They list through
Right.
some other listing company, I would say.
Yeah.
So with them, we have to do this kind of agreements.
So
to get the meeting.
it can be builders, it can be sellers, it can also be buyers. So this is what I want to make sure we understand. This document is not a one side only document. Okay. So for customer status, if you are going to sell it for sell by owner, then you need to put the seller under customer status and fee agreement. Now you could have a situation where the buyer is paying you, so the fee agreement in that circumstance might be 0. Or maybe it is the seller that's paying, and whatever you've agreed to with that for sale by owner, whether it's 2%, 2.5, 3 for doing both sides, whatever that number is, that's in there. And this is a document that's really important. Before you were to draft the offer and send it over to the for sale by owner, you would want this done first, because it needs to be very clear when that consumer receives the offer that they understood that you're not advising them, right? And so your offer, if you were the buyer under section 12 for agency, would have does have agency with the buyer and does not have agency with the seller. But they're not going to understand what that means unless they've received and signed these documents prior to. So it could be a mere posting, it could be a for sale by owner, it could be a builder, it can also be a buyer whom you are dealing with on a double end. So it could be, this would be when you're dealing with your listing and you have someone who calls on a sign call or walks in an open house or emails you through realtor.ca or whatever, and they're interested in purchasing the property. And so you would advise them that you work for the seller, that you're happy to facilitate the transaction. This is what I would be doing for you, and this is what I would not be doing for you. If they're comfortable with that and they are prepared to work with you as a facilitator, you would advise them by giving them the working with a realtor and a customer status form. So the customer status for buyers is a little bit different than the seller one. I've just called it the one thing here. The fee agreement one is the seller version and the buyer one is the regular one. Okay. And you're basically identifying that you have no agency with them and you're not going to break the law, but you're not there to advocate for them. You're there to facilitate, and it outlines that for them. So that would be something that you would fill out before you drafted the offer, to make sure they're very clear. It says right at the top of the buyer document, Do not tell this person your bottom line. Do not tell them anything you do not want them to tell the seller, because your fiduciary duties require you to tell what that buyer in customer status tells you, you have to tell the seller. What the seller tells you, you do not tell the buyer without permission, because that's the difference between agency and no agency. Does that make sense to everybody?
Yep.
So the question often becomes, well, I have a buyer under agency from up here, and now, oh gosh, they've decided they want to buy my listing. So now what do I do? So we're going to talk about that in a minute when we talk about transaction brokerage and when we should and shouldn't use it. So I'm going to kind of combine the two pieces together, okay? But you could also be working with a seller, and you have a buyer under agency who wants to write an offer, but that buyer really needs to be represented. They really shouldn't be a customer. They really need help. And you have a seller who's done 30 deals, you know, maybe it's a builder who, not a builder, but I can't do it for a builder, but maybe it's a client you've worked with for many times, or, you know, this person has lots of experience. You can switch the seller also to be the customer and to keep the buyer under agency and just facilitate with the seller. You can switch either one back and forth. Does that make sense to everybody?
Mhm.
Yep.
Okay. So again, when we're amending agreements for these individual situations, we're going to amend based on the specific property address versus a general sweeping moving clients in and out of arrangements. Okay. So the other questions, so the notes that I had here to make sure was who needs to sign this? Your for sale by owner, your mere posting, a double-ended buyer. Remember that with this document, it does require you to do the working with the real estate industry disclosure form and FINTRAC. That is sort of a given. That goes with every agency document. I did not spell that out for you because I know you guys all know that. And when do I need to get this signed? This needs to be signed prior to the drafting of any documents for that consumer. You can't draft the offer and then go back in time and say, oh, by the way, this is what I'm not doing for you. It needs to be done first, right? Now, first doesn't mean days. It could be that you've met someone in an open house and they're like, I want to write an offer. Well, you got to do the agency stuff first. Then you can draft the offer because they are fully advised of what you are and are not doing before you go further. Does that make sense to everybody?
Yep.
Does anybody have any questions on customer status and or customer status and fee agreement? Oh my gosh, this is great. I have such a well-versed group here. Okay, so now let's talk about transaction brokerage. So who here knows the Ann De Silva opinion of transaction brokerage agreements?
I do.
That would be Michelle. And Michelle, what would my opinion of transaction brokerage be?
Not allowed. Very, very small amount of reasons as to why.
Yes. So thank you for that. I really appreciate it. And you know what? I don't want it to
I
sound.
agree with you.
One of the things that happens with transaction brokerage, this applies, the tendency to want to use transaction brokerage is going to date those people in the industry. So for anybody who used to be in a common law brokerage and where that brokerage switched over to designated, or you've been in this industry longer than about 12 years, transaction brokerage used to be called limited dual agency, and it was just kind of the thing we did, and we all did it wrong. It's just to be honest about how it worked, and that's how you used to double-end a deal. So when I came to Keller Williams, we were about 90 agents at that time, and we had about 90% of all double ends were being done with transaction brokerage.
Wow.
Yeah, wow. So it has taken me a significant amount of time, but I now basically have the brokerage with our 190 or so agents. We are down to receiving probably less than 10 a year. And every single one that is received is immediately brought to my attention. So we have gone from about 90% use to about less than 5%. Okay, and I'm going to explain to you why that matters. So transaction brokerage used to be the mindset about how you did two sides of a deal. And what I need everybody to understand is that when you're in transaction brokerage, you are actually giving up agency for both the seller and the buyer. You are essentially supposed to be Switzerland. Now, I'm going to be very honest. I haven't met a realtor in my career who does not have an opinion about how a deal should be done. If you are that person, I bow to you. We are opinionated humans. This is why we advocate so well for our clients. Is that a fair statement? Right? So to think that we are actually going to become Switzerland, we're kidding ourselves. We're no good at it. We're terrible at it. So what was happening is people were actually advising both sides and trying to do it in a way that was neutral, and it's still wrong. So what happens with transaction brokerage is first you need to understand what is the bar to be in transaction brokerage. So number one, your buyer has to be in a pre-existing buyer designated agency agreement. And that does not mean a buyer designated agency agreement that was signed 5 minutes before you're about to drop this offer. I mean pre-existing. You are out shopping with this person, working regularly, and now they picked my listing, right? Or you get a new listing. Has to be pre-existing. Second of all, that buyer and that seller have to be of the same sophistication level. Similar education, similar knowledge, similar industry experience. You cannot have a super savvy seller and a first-time buyer. You cannot have a real estate flipper and grandma selling her house. You know, I can't have a judge and a nurse. Not that, but it's just a different understanding of law. So I need both consumers to be at the same level. Because that's really hard. And I don't personally want either of you deciding whether that person is of the same sophistication level. That's a huge responsibility. Fair? So I need a pre-existing relationship. I need clients at the same level. Then I have to have the transaction brokerage agreement signed before I ever consider drafting the offer. And I need to explain to my seller what the actual terms of transaction brokerage means. So Shelley, you can be my seller.
Yes.
So I'm going to tell you, so I had this, this person, I've been working with for a while, and or they just called me on a sign, and people think that they still have to put them in under agency when that's not what you're doing. And so I have a client who would like to write an offer on your property.
Yes.
Work with me. Yes.
Lovely. Lovely. Send the offer over.
You're super excited. I'm like, okay, so hang on. So you need to understand that because I am under agency with this person as well, what it means is that I will actually not be able to advise you throughout this transaction. So if we have issues on septic or well or building inspection, I will have to send you back to your lawyer and or to the inspectors to guide you on what to do. I will not be able to advise you on what price we should counter offer with, or how and what terms to create in order to create a favorable offer for you. Oh, and by the way, I would like you to still pay me my full commission while I am in Switzerland. Would you like to sign this agreement? Or I could make the buyer a customer where I'm going to continue to advocate for you, going to keep your confidences and maintain our position of loyalty. And I'm going to facilitate for this buyer. So I work for you, I don't work for them. What they tell me, I tell you. What you tell me, I don't tell them. But we don't have another agent in the middle to get in our way. Which sounds better to you, Shelley?
The latter.
Right. If we actually explain transaction brokerage to a seller in what it actually is, they would never sign it, ever. Because it takes away their rights. The other piece of it is for a buyer, what's really important, if you have a buyer under agency, if you switch them into transaction brokerage, you still aren't facilitating, you're not advocating for them. You become a facilitator. You are not helping a buyer in any way more in transaction brokerage than in customer status. There is no difference to the buyer, but there is a huge difference to the seller. It changes nothing for the buyer. The other part of it is when you are supposedly Switzerland, which we all know we suck at, but moving on from that, and you have a buyer who wants to write this ridiculous thing about something on inspection, and you get it, and you can't do anything with your seller to really tell them how to counter it, to prepare a reasonable solution to go back that you can sell to that consumer. Because you're not supposed to advise anybody on anything. If you're still an agency with your seller, you actually have a better chance of having a better deal done because somebody's getting advice from you, the expert. So if you have a buyer who wishes to purchase a property and it's your listing, that's when you need to say, okay, whoa, here's what happens. Remember we talked about what happens if you pick one of my listings? We're gonna have to have a conversation. I can switch you into customer status where I'm gonna facilitate, make sure everything happens. You're still gonna do your inspections and have choices, but I can't tell you what price to write, and we're gonna do a little bit more consultation with your lawyer. You are going to be facilitated by me, not represented by me. If you want more representation than that, and you outline it by showing them the difference in the working with a real estate agent, then I can refer you to a partner within Keller Williams who will be your agent for the purpose of writing this transaction. If the deal doesn't come together, then you know what? I sent you to Michelle. She's great. If I had to hire someone, that's who I would hire. But if this deal doesn't come together, you come back to me and we go shopping. We look for properties together. But that way, if you need advice, Michelle will be there to have your back. Does this make sense to everybody?
Yep.
So I can honestly tell you, I have only ever seen one in the last 3 years where the circumstances actually merited being a transaction brokerage. Every other time, the person should have been a customer. Somebody should have been a customer. So it's not to say you can't double land. It's to say that this is how you should double land. The risk to you as an agent and the risk to the brokerage, this is the number one area of risk and exposure for litigation is under transaction brokerage. Because you know what? They both still think that you're working for them. They don't get it. They just don't get it. And you can't. You can't advocate for anybody. And you know what? That's not really fair. It's not fair to you. It's not fair to them. We want to do our best for our clients. And sometimes the best is switching their role. So if you have a buyer who you need to switch into customer status, assuming that they're comfortable and sophisticated and ready to do it that way, you would do an amendment to your buyer designated to say, for the purposes of writing I'm offering on 123 Smith Street, the buyer will switch to customer status. Then you do your buyer customer status for that property. If that property does not come together, then it just automatically voids and off you go. If I'm going to send the buyer to Michelle because these people, you know what, it's too complicated. Maybe, for example, they're city people and they're now writing on well and septic and they have never even seen a septic system in their entire life. They should be represented. They might say they know what they're doing, but they have absolutely no idea. And I know they have no idea.
And first-time buyers.
Right. Not necessarily. They could be bought 10 houses, but everything they bought was in the city. And now they're going into well and
First-time buyers who've never bought
it's not a rule for first-time buyers because you could have first-time buyers who are lawyers. You could have first-time buyers whose parents are builders or flippers. It's an information conversation about this is what will happen and this is what I can and cannot do. Are you prepared for this? Are you not prepared for this? And then that's where it also comes down to your gut and it comes down to your ethical boundaries of saying, you know what, I know you're telling me you know how to do this, but I'm going to be very honest with you. Well and septic, as an example, is very complicated and you really, really should be getting advice. And so for the purposes of writing on this transaction, because it matters to me that you have a great experience and that this goes the way it should go, that for the purposes of this, I'm going to send you to Michelle. She's going to take great care of you. And if this deal doesn't come together, we go back out hunting together. So sometimes it's not level of experience and how many deals they've done. But as an example, you could have someone who's lived in condos their entire life and now they want to buy a house in the country and they're going to go as a customer with well and septic. They should be advised. That's an opinion. I think they should be advised unless their person in their family is going to guide them. But those are the types of measures. And so when I do the amendment to my buyer designated to send it to Michelle, I'm going to do the buyer amendment for only that property. So then Michelle doesn't have to do more paper later and I don't have to do more paper later if it doesn't come together. And it's between you guys how you arrange your compensation. If I'm sending Michelle a client where I've shown the property, picked the property, vetted the client, pre-qualified the client, she has to write the deal, maybe I charge her 50%. That's between me and her because it's one deal. It could be 25, it could be just reciprocal. I owe you a client, you owe me a client. We're not going to tell you how to manage your business at that level. Just remember, please do a referral form for the office if you do that, because it keeps our paper simple, okay? But that's the idea, is that transaction brokerage, from a purely practical perspective, is almost impossible to do properly and is really, honestly, our very last resort for doing two sides of a deal. Does anybody have any questions on that? Have I equally terrified you all of it, never wanting to do transaction brokerage? That's my goal. Sorry.
Yep.
Questions, thoughts?
Oh, I agree with you 100%.
And I have a question, but it's back to BDBA.
Sure.
So if I put in if I put in Nova Scotia
Yeah.
and my client, and I put the date September 1st, my client buys in June,
Mm-hmm.
and so that's done. But in August, she decides to buy another house. Can she go to another agent, or does my contract survive the sale of that one property, the purchase of that one property?
Has it closed?
Yes, she bought something and say it's closed, for example. It's not a real example, I'm just wondering.
Yes.
Is she still bound to wait till September 30th if she decides to buy another house, in other words?
Technically, the wording in the BDBA basically states on the completion of a purchase. It sort of implies one property, right? So, and the other offset of that is that whether or not they're purchasing a property you showed them, right? And whether there's a holdover element to it. Very typically, clients are really good about extending. So, you know, and moving forward, you always want to, of course, remember you can't amend to extend if it's already expired. I would have to see the specifics, I think, but generally speaking, it's when it's over, it's over. And generally, it is determined that that one property can represent, under the specific wording of the BDBA, that the contract is done. Tina, I don't know what your message says. It's not showing. That's showing weird. It's like you hit the space bar, maybe by mistake. Oh, you're muted. We can't hear you.
Mute yourself, Tina.
Sorry. Yeah, I hit the bar by mistake. You know, oh, look at that. Why can't you understand that?
Yeah, so the concept being, you know, if you're going to do it, that it survives multiple properties for any property purchase, that would be something that I would recommend that you add in the additional provisions if you have clients that do multiple purchases in a time frame, right? Because there is some minute wording within the BDBA that gives the implication that it is a one purchase document. And again, it's about the spirit of the document. Does that help?
Okay. Yes, thanks.
The other reason, if you have another, when you've put Nova Scotia, what it allows you to do on your consult, and this will go back to David's initial conversation about what am I talking about when I'm prepping my client, it would be when you've put Nova Scotia, it allows you to say, you know, if for some reason your life changes and now you want to go to beautiful Cape Breton, as I have to remember to tell you guys that story about Marianne, and say, you know what, I don't work in Cape Breton, I don't know anything about Cape Breton, it's really an unpleasant commute for me to do an inspection, and so we are always going to have a great partner for you, and I want to make sure that if it's not a KW person, that I'm able to interview and, you know, make sure that we have found the right partner for you, so I can refer you to someone who's going to take equally good care of you as I would. So you're preparing the client that you are going to be their ambassador for real estate throughout the province, and it entitles you to then be able to have that conversation with another peer and to request a referral from that person. Does that make sense?
Perfect. Mm-hmm.
One thing I do want to add about the BDBAs is I want to make sure that we are never, ever teaching or trying to coach our clients how to get out of other people's BDBAs, because you know what? Karma's a you know what. Number one, it's a violation of our duties in our Real Estate Trading Act, and we need to respect the relationships that exist, just like we want that other industry member to respect our relationships. Is it always going to be fair play? No. If you ever have a client who wants out of a buyer designated agreement, and maybe legitimately it's just not the right fit, maybe they have stumbled into an open house, or now their brother's neighbor's dog just got licensed and they want to talk to them, I don't know. Changes and terminations of buyer designateds or seller designateds should always come to me, and then I will join in and advocate and become that person. I'm very, very good at keeping contracts inside Keller Williams and making sure that you get referrals. So this is something where you know, the person that technically owns the contract, which is the broker. When you need to push it up to me to help negotiate on your part, I'm here to do that. I'm very happy to say that is something I rarely have to do. We don't get a lot of people who want away from our great KW family. So you guys do a phenomenal job, but sometimes it's just not the right fit. It could be you have a couple and one of them loves you and the other one is difficult, and we need to, like, it's just not working. Like it's nothing you did. It's just not the right fit. How do we find that right solution? We have 190 or so agents. I can always find the right person that's going to be able to take over. If they really want to move outside the brokerage, then we're going to deal with that as well. But as I say, it's pretty rare, but remember that that's part of my job to help you with that. Pardon me, both on seller and on buyer deals. Does anybody have any other questions on what I'm calling agency fundamentals? Did you guys, hopefully this is my first official foray into this course. I hope you got something from it. I hope that was some valuable information and tips to help you with your business. And just remember that we are all here to help you as a broker team. When you have these questions, you know, you don't have to navigate this yourself. And there's a lot of different scenarios depending on what's happening in your business as to what's the right answer and it's not so black and white. And that just reach out and we'll be here to help you. So if no one else has any questions, I'll let you all free, and thank you so much for taking time out of your day to participate. I really appreciate it.
Thank you. Bye.
Thanks, Anne.
Bye.
Bye.
Thank you.
Thanks, Anne. Another time for the Cape Breton story, I guess.
Oh gosh, yeah, anyone who wants to hear, just really quickly. So Marianne and I were on the board at NSCR for many years together in various different committees. Anyway, every single time Marianne, there could be other Cape Breton people there or someone from the Highland region, which is a different area, even though it's technically in Cape Breton. And when Marianne would do her report, she would always say, it's Marianne McCormick from beautiful Cape Breton. And so it became like her tagline that every time Marianne would talk about anything, it was introduced with, well, of course, it's from beautiful Cape Breton. So whatever you see Marianne or you're messaging her, I encourage you to continue to have this conversation with her because it's just fun.
That's good.
Thanks, everybody. Have a great day.
You.
Bye.
Bye.